Hello everyone, my name is Isha Mitruka and today we'll be dealing with our important judgments for your CLAT examination 2026. Now, why are important judgments so important, right? I know you must be thinking that you will get a passage and then you'll get some questions and then you have to accordingly answer those questions. But in order to answer those questions and to understand the cases, the passages, you need to understand what is going on there. What are they talking about? How the implications arise, and subsequently, you will be able to answer those questions. Without understanding the cases, every question regarding those cases will be incomplete because it might leave a little bit doubt in your mind that you might not have answered the question correctly. That is why you need to have some basic knowledge about some landmark cases along with a few recent cases that have happened in the past 2 years. Which is why in this part one, we'll be talking about how it is important to know landmark judgments, to have a grip of those basic concepts and be familiar with a few basic judgments from various legal fields. It's not important that only one legal field will be talked about or only landmark cases of one or two legal area will be coming in your paper, but it can also happen that you get landmark cases from various fields. That is why today let me educate you about them. Moving on to our first case law, which is Sukhdev Saha versus State of Andhra Pradesh and others. Now, this is very important and it is also a very recent case law. This case law is important because it upholds the integrity, the importance of mental health in our constitution. Now, which article I will leave it up to you for now for a minute or so while I explain the facts of this case. Give me an answer in the comment box about which article does mental health deal with now after this case, if you know. If you don't know, continue with me and find out what part of constitution talks about it. Now, talking about the background of the case. So, this case happened because of a 17-year-old girl who was a NEET aspirant who fell from a building, or that is her hostel building, allegedly by suicide on 2023 July. So, this incident was very grave, very serious, but it was also marked off as a suicide earlier, even though there were some inconsistencies and some markings which showed that it was not a suicide. This case arose by filing of a case by her father, and it was classified as a suicide, but still more investigations were going on. These included investigation was going on the basis of absence of a suicide note. The failure to record the victim's statement after the suicide attempt happened, even though she was not marked as dead. She was aware, she was conscious, and according to the Glasgow's coma score, was 10 on 15, which is why the case went on. There were also further discrepancies in the CCTV footage as well, along with questionable medical handling in her case and the which was administration of a ventilator support without parental consent and a hurried post-mortem by a conflicted medical examiner. So when you look at all of these things together, it points out to some false and grave mistakes that have been made deliberately or mistakenly. But these did not seem right to the father. The postmortem not being handled properly, the medical ventilator support extended without the parental consent, which is usually not the case, and the CCTV footage being ignored, along with the absence of the suicide note, which is rare in case of such suicide attempts. So, because of this, the court also, started a CBI investigation. Now, what happened here was there were multiple petitions from the father to the Andhra Pradesh High Court. The father really wanted justice for his child, and did not want this to be stricken off as a mere suicide attempt, which it was not. As I have told you, why? There were so many inconsistencies. Now, because of this, because of the multiple petitions, there were requests for a CBI investigation as well. The High Court refused to intervene, Even after so many petitions, the High Court refused to intervene because it cited jurisdictional conflicts. Now, what do you mean by jurisdictional conflicts? It means that for a particular area, whether a certain High Court has the right, has the power to interfere or to even register a complaint or register a plaint against any person, any authority, or even start a complaint or hear it. So that is why, due to a jurisdiction conflict with the state of West Bengal, since an FIR was parallelly filed in West Bengal, the High Court of Andhra Pradesh did not hear the request or the petition. Now, because of this, the father was disturbed and feel like there was no transparent or impartial investigation. Due to this, the father appealed to the Supreme Court at last. Now we all know if the High Court, you don't feel like High Court is being taken your matter seriously, or there is some discrepancy of sort, you can go to the Supreme Court. You can approach the Supreme Court, just like the father did in this case, seeking justice for his daughter and systematic accountability in these cases involving student welfare and custodial care. Now, these were the facts of this case. I hope you have understood it clearly. Moving on, what this case did further on is very important. This case reignited the attention of the issue of medical health, including mental health. What we all usually perceive is if you're physically sick, it comes under medical issue. It comes under something that is very important and grave. But many people, they do not consider mental health as an important facet of medical issue because mental health has not been given that much importance in our country. It's still a taboo. That is why to remove this, the case played an important part. It faced, especially in case of students, because this case focused merely on a mental health issue on the students, more importance was given to this. It highlighted the importance of how students face mental health issues because of their examinations, because of the academic pressure, peer pressure, and other related issues, and how it's important to deal with it correctly. Otherwise, it could lead to such attempts in the future as well, as it is going on in the country right now. The absence of a regulatory legal framework that addresses student suicide linked to mental health issues was recognized by the court. For the first time, and for the first landmark time, the court recognized the importance of mental health issue as a part of Article 21. That's right, Article 21, the right to life and liberty and personal liberty included the right to mental health, to live with a sane mental health, to live properly physically and mentally, devoid of any pressure on your mental health is also important. So the absence of a regulatory legal framework was appalling, and the court noticed that the student suicides are linked to mental health, and so Article 21 Constitution was invoked, right? So I hope we are clear till now. If you have any doubts, please ask me in the comment box. The Supreme Court also relied on the line of judgments. Now, when we deal with any cases, there are a line of judgments that the Supreme Court refer to. They are called precedents. So, these precedents help in concrete conclusion of the judgment. It gives backing to the judgment that yes, this has happened before, and because of those, this judgment is also important, and you need to lay more emphasis on this upcoming judgment. It paves the right way for the judgment to be passed. Now, here, Article 21 interpretation was also expanded. Those judgments defined Article 21 beyond mere physical survival to include dignity, to include autonomy and physical well being as well, along with psychological well being. The psychological well being is very important. Please put emphasis on these three things include dignity, autonomy, and psychological well being. Now, two cases were cited while emphasizing the importance of mental health. These two cases were Navtej Singh Johar versus Union of India and Shatrughan Chauhan versus Union of India. I hope you guys are keeping up to date with all the recent judgments. If you are, you'll be able to tell me what these cases talk about. I'll give you a hint about one of these cases, which is Shatrughan Chauhan versus Union of India. It is that it dealt with the mental health of the prisoners in the Indian jails. and how it is important for them, the prisoners who are on death row, to deal with their mental health and how to proceed with their punishment accordingly. Right? Now you can tell me, what does Navteej Singh Johar versus Union of India talks about in the comment box. Further reliance was placed on Mental Healthcare Act 2017. This is a very important act. You should also put more emphasis on this because there is indeed a legislation that deals with mental health care. It especially Section 18 and Section 115 of this very act, it recognizes every person's right to access mental health services. Mental health services meaning your counseling services, your therapists, people who are legally and medically, prepared and trained to deal with your mental health issues, to approach any helpline or of any sort of help you need, and decriminalizing attempted suicide, respectively. This means that this Mental Health Care Act 2017 also helped in decriminalizing attempted suicide. Before this, before the decriminalization, attempted suicide was seen as a crime. The person who committed suicide, he or she would be considered to be a criminal and they would be punished accordingly. But the Mental Health Care Act laid out that attempting suicide is not a small thing. It's a mental health issue because a person with a sane mind would not do it. A person without any mental health issues would not do it. And thus, there's some depression or any other mental health issue that deals with it, which is why decriminalizing it and helping that person, rehabilitating that person is more important instead of punishing them. So I hope this is clear. Now, there are also a list of guidelines which the Supreme Court in this case laid out. There are exactly 15 guidelines that the Supreme Court laid out. I hope you can go back, refer to it, and read it at your own pace. Meanwhile, I will tell you about a few of them. The few of the guidelines are your right and accessibility to your counselors, coaches, and your helpline, toll free helpline services for the students in your coaching institutes, your educational institutions, and all the other institutions where academics is being imparted, where education is being imparted. So, these things are very important for all the students to have such help within their reach. So, counselors and mandatory training of the teachers twice a year at least for the mental health of the students and how to deal with it, how to recognize it is also being said to be laid out by the Supreme Court. It's one of the things that the Supreme Court said is now mandatory. Safe learning environments is also conducive to a proper growth and education of a student, along with stress-free uh, education practices. Segregating of the students according to their pressure, performance, societal pressure, peer pressure, according to their performances, according to their grades, is also looked down upon by the Supreme Court, because of which the Supreme Court said that this practice also should not be continued further from now on. And anti-bullying practices must be conducted, and bullying should be strictly punished and stopped in every sphere of these institutions from now on. This was our first important case in terms of CLAT preparation, and I hope I've explained it well. If you have any doubt, please let me know.